Good. All right. Well, we are just about on time for our start. Thank you all for joining us. We actually, I'm very pleased to see that we have a really good roster of registrants who are desperately wanting to hear about Dewberry versus Dewberry. So thank you for joining us tonight. And we also always expect lots of people to tune in and watch the video after the case because this ends up always being a great quick download. It's a deep dive. It's an efficient way to understand a case. So with that said, let me explain who we are and what we're doing here. So my name is Christine Haight-Farley, and I'm a professor at American University, Washington College of Law, and along with my colleague Michael Carroll, I am the co-faculty director of our program on information justice and intellectual property. We, many years ago now, more than a decade ago, developed this program where whenever the Supreme Court hears oral argument in a case that involves intellectual property, technology law, or something close enough that we're willing to grab and call ours, we hold an event like this at 5 o'clock on the day of the oral argument, and we invite the parties who argued the case, as well as a select number of amicus brief authors, because sometimes there are very many amicus brief authors, and sometimes professors who haven't participated in the case, but who specialize in some of the issues that are central to the case. We sometimes, but not always, convince the parties to participate. Sadly, neither of the parties were able to participate today, but I'm really excited about the panelists that we have and that we'll get to hear from tonight. And I will introduce them briefly. We will talk about the underlying case. We'll talk about the central issue in the case. We'll talk about the arguments made by the parties and the amicus brief authors. We'll talk about the oral argument that happened today, this morning. And I think we will also have an opportunity, a few minutes at the end, to address some of the questions that you might be able to email. To put into the webinar. And if not, maybe somebody can help me. Maybe I'll have a chance to email to see if anybody emails me. But we only have an hour. So without further ado, let me just give you the briefest sketch of the underlying case, which brought us to this moment, but I won't take any of the spotlight on what the issues are that the Supreme Court is asked to address. So the case is Dewberry Group versus Dewberry Engineers. And Dewberry Engineers was the plaintiff in the case below. Dewberry Engineers sued Dewberry Group for trademark infringement. Both of these parties obviously use quite a distinctive word, Dewberry. And that's particularly problematic since both of them operate in the real estate development industry. This dispute has been going on for more than a decade. In a previous dispute, they reached a settlement agreement, but then Dewberry Group did some rebranding, and that is what caused Dewberry Engineers to bring this action. This went to trial, and the district court awarded Dewberry Engineers $43 million in disgorgement of the defendant's profits, plus attorney's fees, and also issued an injunction. Dewberry Group appealed to the Fourth Circuit, and the Fourth Circuit affirmed that award. Yeah, so I think I'll leave it there. I guess I'll just add that, given that our series looks at you know, what the Supreme Court's role is in developing intellectual property law. Just a few years ago, the Supreme Court heard another case on the disgorgement of defendants' profits, and that had to do with the standard that needs to be met in order to get that damages award. And the court there had an opportunity just to simply say that the statute says what it says, and there's no ambiguity in the words. And what we'll probably hear about is the fact that it's subject to the principles of equity, and that seemed to be, you know, make this a more interesting question. So I'll leave it at that. So let me now briefly, very briefly, introduce this amazing panel of experts, because if I gave anything more than the briefest introduction, then we would have no time to discuss the case. So I'll introduce the speakers in the order that you'll first hear from them, but we expect this to be more of a conversational discussion. So Michael Burstein, wave your hand, Michael, is a professor of law at Cardozo School of Law. And I'm especially happy to have him with us today because he teaches and writes in the areas of not only intellectual property, but he focuses on innovation policy and law in entrepreneurship. And I know him to be somebody who knows a lot more than most law professors about business law and corporations law. So I'm happy to have your expertise, Michael. We'll next hear from Sunil Bedi, who is a professor at Indiana University Kelley School of Business. Delighted to have Sunil here because he is a lawyer and a business school professor. So this is a great intersection, and his areas of expertise include intellectual property law, marketing ethics, and branding strategy. Sunil wrote an amicus brief supporting the respondents in the case. Next, we'll hear from Lauren Keller Katzenellenbogen. Okay, Katzenellenbogen, who is a partner at Noby Martins Olson and Bear. Lauren litigates all types of IP disputes, and she was an author of an amicus brief on behalf of the American Intellectual Property Law Association in support of neither party. And we will also hear from Megan Bannigan, who's a partner at Debevoise and Plimpton. And she also specializes in IP litigation and wrote an amicus brief on behalf of the International Trademark Association, also in support of neither party. So I'm very happy to have Lauren and Megan, who are both intellectual property experts, but also, because they do litigation and because they have to think about damages, also have expertise in thinking about the corporate structures of the parties. So I would like to begin with Michael for some basic background. The audience is not a group of corporations specialists, but is a group of people deeply interested in intellectual property. So what do we need to know in terms of the basic background of thinking about suing a defendant and recovering profits from that defendant's affiliated entities who are not named defendants?
So thank you so much, Christine. And thanks so much for hosting the panel, and to American University for putting together this terrific program, and for all of the participants for tuning in this Wednesday afternoon, particularly those of us who are academics and are in the midst of exam writing or grading. So Christine introduced the case very well. Let me just add a few elements of color as to the specific issue. So at the bottom of the case, Dewberry Group, as Christine says, was ordered to disgorge $43 million in profits to Dewberry engineers. But from Dewberry Group's perspective, this order was unlawful for the simple reason that they have no profits. And that's because if you look at the way that John Dewberry, who is the owner of Dewberry Group, structures his business, he has several different corporations. And his different corporations play different roles in the overall real estate development business that he's engaged in. So Dewberry Group, who is the defendant below and the petitioner in the Supreme Court, is what we might call the services business. Dewberry Group provides services to the other corporations. Those other corporations who are not defendants in the suit, right, are not named as trademark infringers themselves, are what we might call the operating companies. So each of those businesses is organized along a geographic dimension. So you have, say, Dewberry, Florida, and Dewberry, DC, and Dewberry, Virginia, and so forth. And each of those operating corporations serves to hold property that it then manages. And sometimes it leases that property and collects rents from the leases. Sometimes it develops that property on behalf of hotel groups or what have you. The way it's structured is that John owns each of these companies. So John owns Dewberry Group, John owns Dewberry, Virginia, John owns Dewberry, Florida. But there's otherwise no relationship between Dewberry Group, Dewberry, Virginia, and Dewberry, Florida. The operating companies are the companies that take in revenues from the real estate development business and retain profits from that business. The service company, who remember is the only defendant in the case, provides services to the operating companies in the form of, for instance, HR, legal, and then all of the substantive services that the operating companies need to carry on the real estate development activities. The operating companies have no employees. It's only services, right, or sorry, the services company, Dewberry Group, that has employees. So the Dewberry Group employees are the ones who are actually performing the tasks required of the operating companies to run the real estate development business. The Dewberry Group charges each of the operating companies a fee for doing this. And one of the disputes in the argument today was over whether that fee is at or below market rates. And that seems to be, an outstanding question of fact in the case. The reason this is a problem is that the Dewberry Group, right, the only named defendant, because they don't own the properties, they don't collect the rents, they only provide services to the operating companies in exchange for a fee, has shown a loss on its books for tax accounting purposes for effectively the last 30 years. John, who owns all of these companies, makes the decision to structure the business this way, to make it so that the services company has no actual profits and the operating companies do. So the question in the case is whether it's possible to attribute to the services company the revenues and therefore the profits of the operating companies. And ordinarily, corporations enjoy limited liability. The shareholders of corporations are not personally liable for the corporation's debts. Corporations also enjoy separate existence. We ordinarily say that the debts of one corporation, are not subject to satisfaction by the assets of another corporation. These two things are separate. There's a big exception to this doctrine. That's the equitable principle of piercing the corporate veil. And in the ordinary case, what piercing the corporate veil means is, in certain circumstances, we can look past the limited liability of the corporation to the owners of that corporation, to the shareholders. In other words, we hold the shareholders personally liable for the corporation's debts, despite the use of the corporate form. That's what in corporate law we call vertical piercing. The problem in this case, and I think one of the things that makes this case conceptually challenging, particularly for the justices as they heard argument this morning, is that this is not a case where the standard sort of vertical piercing the veil would really work. Because if you pierce the veil of the services company of Dewberry Group, you get John Dewberry and John Dewberry's personal assets. You don't necessarily get the assets of the operating companies, which is where the plaintiff, Dewberry Engineering, claims the profits are. In order to reach the assets of the operating companies, you need to engage in something called horizontal piercing, or more commonly, enterprise liability. This is a theory that holds that all of the related corporate entities are effectively one and the same. How does one pierce the veil? Well, there's a two-part legal test. This is an equitable principle for piercing the corporate veil. varies quite a bit from state to state, but generally speaking, it requires the plaintiff to demonstrate that the corporations have a unity of interest and ownership. They're effectively run as sort of one thing or as the alter ego for the shareholder in the vertical piercing case or each other in the horizontal piercing case. And then some aspect of fraud or injustice, right? Some sense in which organizing the business this way, perpetrated, a fraud with Scienter. And that's a hard thing to show. So the defendant in the case, Dewberry Group, argues that you cannot reach the profits of the operating companies without piercing the veil in this way. Dewberry Engineering, the plaintiff in the case, argues that, in fact, a whole bunch of other possibilities exist for reaching the assets of the affiliates. And that's where things stood as of the argument this morning.
Thank you, Michael. That was really great because even I understood that. So that's going to be my standard. So thank you so much for that. Sunil, I didn't mention when introducing you who you wrote the amicus brief on behalf of, but you wrote the amicus brief on behalf of professors who are expert in trademark law and corporate law. And I wonder if you could begin by just telling us, and I'll ask Lauren and Megan as well, just why, why did you take an interest in this case and do the work to write a brief? And could you please just let us know what the main argument of the brief was?
Yeah, no, absolutely. Thanks, Christine, for the invite. Thanks to American University and Michael. Thank you for a really nice background. I was going to ask you, Michael, is there a way to go up the chain and then down the chain? But it seems like what you're saying is, which is it's a horizontal piercing it's almost its own sort of whatever legal theory. So I'd be curious to see what your thoughts on if they went up to Dewberry, the guy, and then they could somehow go down, and maybe Lauren and Megan can also help me think through that. But yeah, so thank you, Christine. I wrote this amicus on behalf of a couple IP professors. One is in a law school and one is in a business school. And most of my research for the past several years has been focused less on the doctrinal aspect of IP and much more on what I sort of say is the descriptive business side of IP. So I have a PhD in marketing, and most of my research focuses on branding, but not necessarily how we as the law treat brands, but more how brand strategists think about brands and how businesses who are engaging in this branding sort of endeavor think about brands. And the reason I thought this was a cool case is because I thought it would give me an opportunity to try to insert a little bit of sort of a little bit of like branding scholarship and how sort of business school scholars or marketing scholars would think about this issue. And I'll talk a little bit about what that was. Of course, the oral arguments in no way, shape, or form resembled sort of what I was trying to sort of insert, which is totally fine. I wasn't under the guise that no one was, people were really going to find my argument convincing in that way. But what I tried to do is think about what I would call a descriptive point. And the descriptive point is the following. When we think of a brand and we think of a trademark, which is sort of synonymous in many ways with the brand, maybe not, depending on how we think about it. But the idea is that there's various ways to value that. So we've thought about profit, the profit you get by infringing, the disgorgement, and that release of disgorgement. We think about price premiums. We think about goodwill value. There's all these different ways of measuring what the value of a brand is. And what I wanted to sort of talk about in the amicus, which is what we did, is think about descriptively, how do brand managers thinking about strategically how they use brands, how do they think of the value of a brand? And there, what I, based on my research, based on sort of a lot of branding scholarship, brand managers think about brand strategy in a very holistic way. They don't think about brand strategy as simply this entity that holds the trademark or infringes on the trademark. They sort of do what we call brand architecture strategy. So what does that mean? Well, basically what that means is they view, or they at least try to set up a structure of companies that utilize either it's one brand, many brands, a parent brand, a subsidiary brand, in a way to maximize sort of profit. So an example would be something like Johnson and Johnson is a brand, but then has all these other sub brands, right? And it sort of sometimes says Johnson and Johnson is associated with this, sometimes it doesn't. Sometimes the affiliate brands, which are like the bottom, so if Johnson and Johnson is here, the bottom ones, sometimes they will co-brand with each other. And so the idea is if you are a brand scholar or a brand practitioner looking at this, you're not just looking descriptively at this one point. You're looking at how the brand impacts all of the affiliates. And in particular, you're looking at what I call spillover effects. I don't call this, but I say this in the amicus brief, but this is sort of what marketing scholars would say, where spillover effects of one affiliate using the brand of another affiliate. And does that have an effect on the affiliate, but does it also have an effect back on the original company that's using it? And these spillover effects can be positive, they can be negative. And so what the amicus brief does, what the argument we made was, you know, descriptively, this is how people sort of structure brands or a company of brands. They are thinking about affiliates. They are thinking about how these things go back and forth. Of course, there's a separate normative question of, even if this is the descriptive case, ought we to take this into consideration when we're thinking about disgorgement of profits? And there, you know, I think there's good standing, as sort of Michael says, really good standing literature and sort of theories on corporate separateness. And we can talk a little bit about how I think the respondents tried to get around corporate separateness and piercing the corporate veil. But just to recap, the point I was trying to make, I think, in the amicus with sort of my my colleagues, was that descriptively, this is how people think about sort of managing brands. Whether or not we want to, you know, sort of enshrine that in the Lanham Act and enshrine that in, you know, equitable remedies, yeah, I sort of leave it up to the court, you know. But I wanted to sort of, again, I don't know if I was successful, but I wanted to sort of insert this sort of descriptive business focus of brands into the case. I'll leave it at that for now.
Yeah, great. Thank you very much for that. You know, I think that really, one of the questions was this kind of default position of corporate separateness. Does this sometimes get us into being too formalistic in our way of viewing that? And I think your research and your brief really addresses that. Okay, great. So now let me turn to our other amicus brief authors who very unfun were supporting neither party. I mean, come on. But in fact, I think both your two amicus briefs were very complementary. You didn't cover the same terrain, but you very much complemented each other. Again, on behalf of two IP organizations who almost always file amicus briefs if there's something, especially speaking for INTA, relevant to trademarks. But Lauren, if you could begin and just tell us, you know, what in particular was the interest of the AIPLA, and what did you argue in your brief?
Sure, I'm happy to. So as a practitioner that brings a lot of trademark lawsuits, the disgorgement as a measure of damages is very important to us because often in a trademark suit, it's really hard to show actual damages. I mean, maybe next time I'll go to Sunil and he can help me out with some actual damages to the brand. But, you know, it's often really difficult because it's difficult to show actual lost sales. Often the measure of damages you're relying on is disgorgement of profits due to the infringement. And this was a case where it seemed like a fair result was reached in the end, but there wasn't a whole lot of guidance or analysis in how the district court and then the Fourth Circuit got there. And AIPLA was really concerned about that lack of guidance. And we recognized, it was interesting, I was on a number of calls with the AIPLA board, and there were people that felt very strongly on both sides of this issue. There was a lot of debate, but you know, we were very concerned that the district courts do need discretion, and this seemed like a case where discretion might be very appropriate because there were, as you know, as Michael and Sunil have discussed, there were these entities that were all owned by one owner but were separate corporate entities. And yet it wasn't clear that any of those holding company, I mean, based on the record we had, we couldn't tell, even if those holding company entities had been defendants, it wasn't entirely clear whether they were directly infringing or whether there would have been a theory of contributory infringement by which they could have been held liable. And so it really did seem, I don't think there was any evidence that it was an intentional attempt at avoiding liability for trademark infringement. I don't think that was what it was, but it gave the appearance of a scary way that companies could divide up the infringement and the profits if there wasn't a way to go after them. And yet at the same time, a lot of people at AIPLA were very concerned about maintaining the corporate separateness and the fact that a lot of our businesses, economy rely on those principles of corporate separateness. And this was also a scary decision in that there wasn't a discussion of piercing the corporate veil or a discussion of fraud, and a lot of that was because that didn't, that wasn't in the record from below, because that wasn't a theory that was raised by the parties. And so we were very concerned about that lack of guidance. And then a lack of guidance of, there are times when it's important for courts to have that discretion, but there wasn't a lot of guidance of what made this one of those times. What were the circumstances here, and what should courts look at to say, is this one of those places where we should exercise our discretion?
Thank you very much for that, Lauren. It's interesting. We'll turn to the oral argument today. But if one of the driving forces of writing a brief and becoming engaged in this case was to help get some guidance about when corporate separateness is not appropriate, I don't know that this case is set up to allow the court to do that in anything other than what would be, very clearly dicta. And I do want to talk about what will happen from here and what your predictions are. But first, Megan, I'm very what you have to say.
I completely agree with you that this might yet be another case where we don't actually have a clear answer or guidance going forward, but we can get there. That's just a spoiler. So you are right. Our INTA's brief was very complimentary to AIPLA's brief. And look, I think this is a perfect example where bad facts make bad law at times. And we've seen this over and over again, especially with some of the recent cases that have gone up to the Supreme Court. When you read this Fourth Circuit opinion and you look at the underlying facts, I think everyone's reaction was first, wow, these are bad players. They did do something bad. There's some funky thing going on with the corporate separateness here. And it shouldn't be a case where you can't disgorge any profits. But when you look at what the Fourth Circuit actually did, and frankly, what the parties did in litigating this, it was clear that the Fourth Circuit was relying on profits of a non-party when deciding what the profits to be disgorged were. And that is really dangerous. And that's what had the International Trademark Association concerned. Because look, and we're taking no position on what actually should have happened in this case, because like Lauren so well stated, it was really unclear what actually happened and what were the facts in this case. And so we're not in a position to say, should there be a bigger damages award? But we have to look at this as a slippery slope. And if there's an opinion, a circuit opinion out there that says a court can essentially consider a non-party's profits when disgorging defendants' profits, I mean, what impact will that have for future cases? I mean, obviously, respecting corporate formalities was incredibly important to us. Think about all of our brands have corporate formalities, and there are ways to get at, other aspects of a corporation or subsidiaries or parents. There's express ways to do that within the law. You can pierce the corporate veil. You can argue alter ego. Agency theory was talked about today. Or you can just sue a party if they're a proper defendant. None of that happened in this case. I thought it was very telling during the oral argument today. The justices fixated on that at a certain point. One of the justices actually asked, why didn't you sue them? Like, what happened? Why didn't you do this? And petitioner's counsel's argument his response surprised me. He said, well, we looked at the website and we just didn't know that we should have sued the other parties. I was a bit surprised by that. We can talk about that later. But look, there was these tactical decisions just didn't happen during the course of the litigation. The Solicitor General made the point today that maybe they wouldn't have been able to make any of these arguments. Maybe the facts weren't there and there needs to be some other avenue. But what will this do to litigation going forward and to the disgorgement of profits? The statute is very clear that you're allowed to disgorge defendants' profits, and that's not what happened here. And so the concerns and the risks that INCA highlighted in the brief, exposing corporations to unpredictable and expansive liability, destabilizing the clear boundaries of corporate law that facilitates business operations, like raising capital, launching enterprises, estimating risks. And then you just open the floodgates for expensive, burdensome fishing expeditions for discovery. I mean, I was having nightmares just thinking about this. When they're thinking about propounding discovery requests, that suddenly it's fair game to go after corporate affiliates and what their profits are. And you can just see that being a mess. And then there's also, permitting plaintiffs to use the threat of disgorgement of other entities as leverage. And so, there has to be some kind of clear rule here. I'm not sure that's what we're going to get out of this opinion, but let me not jump the gun. We can get there.
You guys have all been so disciplined and preserved our future conversation. Thank you so much, but really building it up as we go. I think that the one thing that I'd like to bring out now, and I don't want to target any one of you in particular to help me bring this out, is that we had a brief and oral argument by the Solicitor General. And, when I looked at the briefs leading up to the case, I felt pretty, I don't know if I should say, I would make a prediction about what the court is going to do. But the Solicitor General did a little of, well, on the one hand, but on the other hand, yes, kind of really as both Lauren and Megan were bringing out, and Michael as well. Not that you were not objective and comprehensive, Sunil, but you were you were making a particular point. But on the one hand, we do start with this very fundamental notion of corporate separateness, and the Solicitor General seemed troubled by the Fourth Circuit's opinion there, but it wasn't a slam dunk, right? That it isn't. I think the Solicitor General did not want to just suggest, a mistake was made here, the court should correct it, but very clearly said, this should be vacated, this award should be vacated. But how do we deal with these principles of equity and how they operate here? And I think the Solicitor General was wide-eyed in thinking about how, especially with vacating or overruling the Fourth Circuit, there could be kind of a green light for all kinds of troublemaking, and came close to suggesting there was trouble, happening below, right? Just talking about, how a corporation can set up their books, right? And how those books can be set up in somewhat of a deceptive manner, which would evade any, in this case, any damages at all, right? There was an injunction, there was attorneys' fees, but any other damages at all. And so the Solicitor General was hinting at ways to use these principles of equity to do something. And I'll just ask you all to jump in if you would like, to talk about, what the Solicitor General's position was. Michael, do you want to begin?
Yeah, sure. I can start. I think the SG's brief reflects a frustration in the case that was shared by the justices at argument this morning. And I think it's a frustration that the district court and the Fourth Circuit below didn't do the work to justify this disgorgement remedy. And so I read the SG's brief, particularly, after listening to the assistant to the Solicitor General who argued this morning, as sort of, a call for, vacator and remand for the lower courts to actually figure out what is the principled basis, if any exists, for this disgorgement, right? So the SG, doesn't agree with the petitioner that piercing the veil is the only potential equitable principle that might be invoked, to reach the operating company's profits. And interestingly, Tom Hungar, who argued for the petitioners, who's a very able advocate and a former boss of mine, I think he moved off that position a little bit and was kind of to my mind, a significant concession, right? That actually piercing the veil wasn't the only equitable approach to disgorgement. But the SG's position is that, they have a test, right? The SG says, if you can attribute economic gain to the defendant, even though it's the other entities that as an accounting matter, realize that gain, then that in the SG's, view is sort of, an equitable approach to disgorgement here. And the SG also disagrees with the respondent, right, with engineers, that, any sort of just sum under the statute, right, that the district court sort of has discretion, to sort of do what it wants in the interest of equity. So the SG tries to steer this middle course, but I think more than anything, they're just dissatisfied with the work that the courts below did. And I think the justices are too.
I mean, I think, can I jump in here if you're Christine? Yeah. So, I mean, I think you're exactly right, Michael. I think that's exactly what sort of is going on in the SG's mind. And I think it's also going on in all the justices' mind as well. I mean, I think that as I was reading, the transcript, there's a really nice back and forth between the respondents, counsel Lynn and Gorsuch, where Lynn basically says, oh, there's other ways. We start with separateness. There's the disregarding corporate separateness is not an end in itself. It's a means to an end. And then it goes, he sort of says there's all these other ways, right? So he says like, yeah, it's piercing the corporate veil. There's assumptions, alter ego, there's waiver, estoppel. It kind of goes through this. And Gorsuch goes, okay, cool. But what did the Fourth Circuit say then? And he's like,
yeah.
And then Lynn says, oh, well, the Fourth Circuit did have a reasoning. And it's like, okay, what's the reasoning? And he says, well, the revenues were under common ownership is the reasoning, and cites something. And you're like, and even when I was listening to that, even though I'm, in support of that, I was like, that's not a good argument. Like, I don't think that's what the Fourth Circuit did. And so I don't know, I don't even know what the Fourth Circuit did. And so I think that is exactly what Michael's saying. What's going on here, I think, is even the respondent is sort of in this mode where they're like, okay, well, something has to have happened here. Clearly something maybe bad happened, maybe not, but we should be getting something. There are all these different remedies available. The Fourth Circuit must have given us one of them, but the respondent couldn't really articulate what that remedy was or what the justification of sort of looking at the affiliates was. And I think that's judges are like, give us something. And the judges don't want to come up with something because that's not, and so I think exactly right. I think the SG is asking for a remand rather than, a complete reversal.
Yeah. And, and the respondent, and I'm curious what Megan and Lauren think, about the respondent's litigation strategy, because to my mind, the respondent's in a tough position, right? They cannot say vacate and remand, right? They need to defend the Fourth Circuit's work to preserve their judgment. So in some sense, the SG has the luxury of being able to say, well, we think the Fourth Circuit got the law wrong, so just vacate and remand. And poor Elbert, who's also a very skilled advocate, sort of had to defend, the Fourth Circuit's work here, and the Fourth Circuit disposed of the disgorgement question in a paragraph, right? That just was not very well reasoned. And I think he did his best. But as you point out, that exchange with Justice Gorsuch in particular, was pretty enlightening.
Megan or Lauren, do you want to jump in?
Yeah, sure. I did think it was interesting. There were a lot of questions from the justices about the fact that it wasn't an arm's length transaction between these various companies. And, the response was often, well, there just wasn't anything about that in the record, and that's clearly the problem that everybody's facing. And so, but if the case is remanded, then it can go back to the district court, and the district court, I think, as one of the justices pointed out, could reopen it and allow the parties to develop the record more, which seems like it would be a better solution for everybody all around. But yeah, I mean, I think that is ultimately the problem. And it is a super tough at this point for the respondent where they've gotten themselves. They're in a super tough position because, yeah, I mean, they got a good result and they have to fight for the Fourth Circuit. But yeah, there's just not a whole lot in the record to help them right now.
I think the argument was telling today. Mr. Lynn almost threw his hands up. I imagine what it looked like in the room, having not been able to see it. But you can see towards the end, as the justices, many of them were really pushing. We all agree that the Fourth Circuit got it wrong. We all agree. And it's like, well, they got it wrong. Well, no, you can't use defendants' profits, but you can do what you did. It's an evidentiary issue. This is an evidentiary issue. Does this meet the just sum test? Does this meet the principles of equity? Yes, there are a lot of bad facts here. What the Fourth Circuit did was fine. The evidence is there. And if you have to remand, fine, remand, but the evidence is there. So it was really tough. I agree with Lauren. I think it was interesting. The justices pushed everybody who argued to agree that what the Fourth Circuit did was wrong. And then, they're just asking for different results. So the petitioner wants the award to be reversed and wants this to be done because, the argument is they didn't pierce the corporate veil. There is an alter ego theory. There isn't anything more in this principles of equity. It's just not in the record. They didn't raise this. These have been waived. It's not there. This case is done. Sorry that you didn't do your job, but you didn't. It's done. The Solicitor General says, well, not so fast. Why don't you remand back and actually give us a test? Like, let's talk about this arm's length transactions. And if it's not, what would the value be? What would the profits be if we're looking at it from an arm's length transaction? And that might be better than just some vague language. Give us a test. It seems pretty clear the justices did not want to give a test. At least Justice Barrett said over and over again, this can be a very narrow decision. All we have to say is that let's answer the question presented. Let's go back to the question presented. The question presented is whether you can take into account non-affiliates' profits when deciding a disgorgement of profits. The answer is no. And so that's why I am concerned that we are going to get a very narrow, a very short opinion. I suspect there is going to be a remand, but what happens on remand and what the court does there, it doesn't sound like there is much interest in explaining more what the principles of equity mean or what this just sum test means. And then, of course, I already mentioned the third position, which was, well, the Fourth Circuit, you can't use the profits of a non-affiliated entity, but it's evidentiary, there's evidence, and this is within the bounds of principles of equity. So it will be very interesting to see how they come out. But it does sound like this will be vacated in some respect.
So
I think as a matter of prediction, that's got to be right. It's interesting though. I don't know what, I presume if it gets remanded to the Fourth Circuit's just going to remand to the district court, right? And we're going to be back sort of for more fact finding. And I don't know what's going to happen then on remand, because to my mind, the SG's test is a weird one, right? How do you sort of calculate the economic gain to the services company from the absence of arm's length transaction, right? What's the counterfactual? How do you simulate arm's length transactions with the operating companies? And that's difficult because I think, as Tom Hungar, as counsel for the petitioner pointed out, the fee charged by the services company to the operating companies is really just an internal transfer price that takes account of lots of things, that may not be dependent on the underlying trademark infringement. And so trying to disentangle, this guy, right, John Dewberry's, internal transfer price among his companies is going to be, I think, a real factual challenge on remand in the district court. But on the other hand, I thought, I thought Elbert Lynn's, best moment in the argument came in an exchange with Justice Kagan, where he said, the fact finding below says three things. The operating companies generated all the revenue. Dewberry controlled, which entities that revenue was allocated to, and all of those revenues were on the affiliates' books. So why can't we sort of, under sort of equitable principles, access those revenues? I think it's going to be a real challenge on remand too, if even if that consensus in this group is that that's where it's going.
The one thing that concerned me is that, I agree. I like that exchange as well, and I thought that exchange was persuasive. But there doesn't seem to be any clear opinion, or at least you couldn't tell whether, how far you can go with the principles of equity and how far you can go with this just some principle. And so I do worry on remand, we're stuck in the same place. Like, do you have to pierce the corporate veil? Are they out of luck because they didn't do this? I mean, I do suspect that there were just some tactical decisions made or not thought about until after the record was closed. That would be my guess. Like, who knows what actually happened? And, how far is the court going to go to, how much does the court really think that these profits deserve to be disgorged, and where does that get us with the principles of equity? And that it's just a big, I hope we do have some kind of direction about whether they're limited and what you do with the corporate form, because I can see us ending up in the same place a year or two from now, depending on how much, whether they do more fact finding at the lower levels.
Yeah, I agree with that. I felt like based on the justices' questions, a lot of them went to the lack of the information that we needed from below, but there weren't a lot of questions directed to trying to determine the limits of discretion within principles of equity and trying to provide guidance or determine what that guidance should be. So I kind of agree we're not likely to get that sort of guidance that we would prefer to have, so.
Christine, I have a question for the panelists, if that's all right. I don't know is that taboo? Is the panelist allowed to ask other panelists?
Yeah.
I'm just going to anyways. Okay.
Yeah, and just cold call on people too.
Yeah, right. That's my long. Okay, so this is a professor question, and maybe Michael will not like me for asking this. So, I know, Christine, this is an IP. We're focusing on the IP at the Supreme Court. So, obviously, all of the debate, all the oral argument focuses on, what I would consider, and I assume Michael would agree with me, traditional business law, corporate law issues. To what degree do you think these issues are unique to the IP context, and in particular to the trademark context? Because if they're unique to the trademark context, which I don't know if they are, but my hunch is, and this is sort of getting back to my amicus, that this notion of brands and brands being able to be affiliated with entities that aren't necessarily in a vertical structure but horizontal structure is much more common than it would be with a real estate asset, even though this is about real estate, or like a physical asset. And so I wonder to my panelists, to what degree do you think this is a trademark issue? Or what degree do you think this is just a standard corporate law issue? And if it's a trademark issue, is there room to do something different that we would do outside of the trademark context, given that it's a trademark issue? It's my professor question. I don't know the answer. That's my question.
Am I being cold called?
Yeah, Michael, go for it.
I suppose turnabout is fair play as a professor, right? We do it to our students.
There we go.
So I think it is a common corporate law issue that is particularly challenging in the trademark context, right? So I actually found it very interesting that there was no discussion at argument. I think Tom mentioned it once of, the case that the petitioners relied upon principally, United States versus Best Foods, right? For the principle that federal courts will assume Congress means to preserve corporate separateness absent some sort of clear statement. So that case was, a case about damages apportionment, rather than disgorgement. So the equity piece was out of it, but that was a CERCLA case, right? That was an environmental damages case. And no one seemed to want to discuss that. So the statutory construction issue kind of fell out of the argument in a way that I was not expecting. And instead the justices really were focused on, to the extent they were focused on the substance of a test at all, what the approach to equity was, sort of assuming that equity was built into, the statute, right, as a matter of statutory construction. And I think that's more challenging in the trademark context because disgorgement is more challenging in the trademark context, right? As sort of an equitable remedy where you seek to, make the plaintiff whole. The very reason we have that in trademarks is because trademark damages can be so difficult to calculate. And I think that makes the disgorgement calculation also really hard because it's difficult to attribute, some portion of the profits to the infringement. And so that's sort of a long way of saying, common issue, particularly challenging, in this context. That's my take, at least.
Sunil, I was asking myself the same question as soon as I started looking into this case. I feel like the Supreme Court really hates the argument that IP is special or trademark is special or anything like that.
Me too.
And yeah.
No.
Yeah, so it didn't seem like that would be persuasive to the court to argue that, we have to have a special workaround the corporate separateness in the case of trademarks. That seemed like it was going to be a losing argument, especially without anything more than principles of equity in the statute. So just because we're running out of time, I think we are probably all in agreement. I think anybody who was at the argument or read the transcript or even read the briefs in advance has a sense of where the Supreme Court is going. We're not usually in this situation. And yet, as always, we don't know exactly where they're going to go, right? So what the Fourth Circuit did is wrong, right? I think that the court has to say to some extent whether, as Lauren mentioned, whether they're going to address the question presented and say, the statute says defendant, you can't disgorge from a non-defendant, and that's the end of it. It doesn't seem like the court would probably even go that far as to really completely answer the question that's presented. And I think the real question is, how, if at all, can they so really, and I think Megan said this, how narrow is this narrow decision going to be? There was what I thought was an interesting exchange between Chief Justice Roberts and the Solicitor General on, to what extent is the question preserved below? Like, does this really just die? Is this the end of it? Or is there something? And the Solicitor General kept saying, well, yeah, we got questions. We got questions about how to do this. We think the best place to answer those questions is below. And Chief Justice Roberts said, but can they even, has this just been done wrong from the outset? So any final thoughts on what we might hear from the Supreme Court and to what extent that's going to keep Lauren and Megan in business?
I mean, I've given my view that I think that this could be narrow. I think this will be vacated in some respect, but to me, it's a big open question about whether the court says anything about what the principles of equity mean. It didn't sound that way, although Justice Kagan asked a lot of questions about the just some language and what that means. So it is possible we could see something from her or in a majority opinion or in a concurrence about what that might mean. I could certainly see this being an opinion where there may be in a concurrence or two going a little bit further, as we've seen, for instance, in the Abertron opinion recently. But it is hard to say. And I also found it very interesting when the Solicitor General when they were pushed on, well, what happened? Why didn't you take a position here? Why aren't you taking a position? You've taken a position in other cases. What's so special about this case that you're not taking a position? And I think that was Chief Justice Roberts that did that. So you can tell that the facts below are shaky, and all of each one that argued this seems to implicitly agree that the facts below are shaky. So who knows what will happen? But I do not think we've seen the end of this yet.
Maybe that gives me an opening to ask the question I always ask when we discuss these Supreme Court cases, which is, why did the court take this case? Like, does the court not read the decisions below before they grant cert in a case? Like, this is not, so many of the cases that the court takes are not great vehicles to do any fixes in the law, and this certainly seems that way.
You know, but
It's like the
before
Neely case recently. Like, here's the small question. We're not going to answer the big question. And it really felt like that's what we're going to get again here.
Yeah,
Yeah,
I mean, when we were discussing it at AIPLA, we initially thought maybe the Supreme Court took this case to, again, emphasize the point that you said before, that these principles of corporate separateness aren't special in the trademark or IP context, and that maybe this was just going to be another one of there's nothing special for the trademark context. But based on oral arguments, I don't know. It's hard to say why they took this one. So.
you know, before the argument began this morning, the court issued a dig, a dismissed as improvidently granted in the NVIDIA case. And that's the second dig already this term. So something is weird with their case selection lately. And maybe this is just another example.
Great. Well, I want to thank each of you for your to Sunil and Lauren and Megan for your really thoughtful briefs that I hope contribute to our understanding, even if their insights don't make it into the very short, hopefully quite narrow decision that we get from the court. And I want to thank all of you, Michael, especially for providing the kind of background structure that we needed in corporate law. Thanks to the audience for tuning in. I'm sorry that we didn't get a chance to answer the questions, but maybe I can convince the panelists to stay on a little bit and I can get you some answers. Thank you. I just want to let the audience know that we will, as soon as we get the video transcribed, we'll post it. And we have a YouTube channel that includes all of the videos for all of the cases over the past 10 years. Thank you very much.